Hi all, hope you all are safe and at home. Today I am going to discuss with you all the topic of criminal complaint. Criminal complaint is of two types. One is an FIR and second is a criminal complaint, that is a private complaint. Now let us see what is FIR. FIR means first information report. As the name suggests only, it is the information which reaches the police station first in time about commission of a cognizable offence. The most essential and important ingredients for registration of an FIR are: it should be an information, and second, it should be an cognizable offence. The term FIR is not defined anywhere in Criminal Procedure Code, but you will find reference to the term FIR in section 154 of the Criminal Procedure Code. The station house officer or the police station in charge, upon receipt of an information, the information that is either oral or written, is duty bound to register the FIR, that is by converting the information into a statement and taking the sign of the complainant, is duty bound to register an FIR. The officer at that time does not have the prerogative of verifying the contents of the information. Mere disclosure of a cognizable offence is sufficient to register an FIR. After registering the FIR, as per section 154(2), it is mandatory for the officer to give the copy of the FIR to the complainant free of cost. No police officer can charge for the copy of the FIR. Let us now see what questions always arise in the mind while giving an FIR. First, who should give an FIR? The FIR should be given either by the victim or anyone who has knowledge of a crime, or anyone who has hearsay of a crime, or who is a witness to the crime. Understand, hiding a crime is a bigger offense than reporting a crime or committing a crime. Now second question is, in what language the FIR should be registered? The FIR is generally registered in the local language of the police station. What if you do not know the local language? Then what should you do? Suppose the language best known to you is English. Then take your complaint in writing and give it to the police station. The officer is duty bound to convert it into the language of the police station and translate it to the complainant. If at all the officer does not know the language known to the complainant, then the officer always has to call upon a translator and narrate the contents to the complainant. The complainant, only and if only the facts are as per his or her narration, is duty bound to sign the FIR. If the facts you want are not mentioned in the FIR, that is the statement, please inform the officer to note down the same. Hence, it is always advised to give a written complaint, because if the police officer refuses to take cognizance of your complaint, then you can go to the higher authorities. Why should you always sign the FIR or the statement? It is mandatory and essential for a complainant to sign the FIR, because refusal by the complainant to sign the FIR attracts penal provisions as per section 180 of the Indian Penal Code. Now let us see where can you give the FIR. The FIR or the complaint has to be given to the police station where the victim resides or the place where the crime has been committed. Can the FIR be given where the accused resides? Generally, it is not to be given where the accused resides. Now let us see what happens if you are not at the place where you are residing. Then here comes into picture the concept of zero FIR. Zero FIR is a concept where information is given to the police station and the station house officer immediately registers the offence. But upon registering an offence, he understands that he does not have the jurisdiction to record the FIR. Then at that time, he transfers the FIR either to the place where the victim resides or the place or the police station where the offence has been committed. Stopping at this moment, what would be evidentiary value of an FIR? Because all are keen to know that FIR sets criminal law in motion, then how could there be an evidentiary value? So, pausing here and stating that FIR holds very less evidentiary value. Reason being because it is given to the police station and it is not given in the court of law, or nor is it tested by cross-examination, or nor it is given on oath. Then the question would arise to the mind is, then why is FIR important? The FIR is important because it can be used for corroboration or contradiction to the person giving the FIR, that is the complainant. Now let us see what is exactly stating that. When the complainant is put in the dock, that is in the trial for cross examination, if any vital fact is missing from the FIR, then he can be crossed upon it and those facts can be noted before the court, which would help the accused in proving his innocence. Now what statements in FIR can amount to substantial evidence? Two statements can amount to substantial evidence. First is dying declaration. Dying declaration is a declaration where the person giving the FIR dies in between. Then at that time, that statement can be used as an FIR. Secondly, if a complainant is being assaulted in the police station in the presence of a police officer and the complainant informs the police officer that the accused was assaulting him, abusing him or committing any overt act, then that can be used as substantial evidence. Now you will be thinking, what happens if the accused himself gives an FIR? This is a very rare case and very rarely it happens, because if the accused gives an FIR, then he can never be put for cross-examination as per section 315 of CRPC and he will never be available for giving evidence as a prosecution witness. Hence, it is very rare that an accused gives an FIR. If an accused gives a confessional statement as an FIR, then that cannot be used as statement against co-accused as per the provisions of Evidence Act. But that can be used for proving his conduct as per section 8 of the Evidence Act if it is a non-confessional statement. Now the question that next arises to our mind is, within how much time should an FIR be registered? An FIR should be registered as early as possible without any delay. Reason being because as it delays, the action delays and the memory of the complainant embellishes. There are exceptional circumstances where the delay can be condoned, but there is not a particular circumstance or not a particular test that can release every FIR into delay conduct. Every case has to be adjudicated differently as per the knowledge and judicious mind of the court. Now the next question is, what all should we give along with an FIR? It is always stated that when you give your FIR, always annex the evidences which you have, so it helps the police to investigate better and also helps them to file the report fast. Now what should be the evidences that you should give in the FIR? Evidences means, for example, if you are giving a cheating complaint, for example, A promises B to give him double the amount in 3 months. So please give first the communication what was between A and B. Secondly, please annex the mode in which the payment was given to B, and thirdly, the main ingredient which prove the same to be cheating annex. Now the main ingredient which would prove the same to be cheating is, after 3 months, if the money was not double and A kept on delaying and avoiding B, then that could be an evidence. Secondly, what is most important is always write your complaint as per the chronology, that is the date which have occurred. Please do not jumble up dates and give your details. FIR is not expected to be an encyclopedia, but FIR has to be precise and the content should be right, because tomorrow in the court of law it should stand the test of cross-examination and it should corroborate with the theory of the complainant. Now the most important things are where the offense was committed, how the offense was committed, who is the accused to the accused, and what is your relation to the victim. Now whether there can be two FIRs of a same incident? No, there cannot be two FIRs of a same incident, but there can be multiple victims of a same incident. Now which FIR will be the first in point? Like for example, let me tell you, A and B were cheated by C. A resides in Thane and B resides in Churchgate. Both come to know that there was cheating. B gives the FIR on 25th December 2017 at 9 am and A gives the FIR at 26th December 2017 at 10 am. Then the FIR given by A would not be substantiated. The FIR given by B would be substantiated as it was given first in time, and the FIR of A would be transferred to Mumbai and both the investigation would start in time. Now What statements cannot be an FIR? Firstly, any statements which are made after commencement of an investigation. Any statements which are made after multiple delay. Vague informations. For example, a person is lying in pool of blood. Cannot be an FIR. It has to be detailed. A telegram cannot be an FIR. A cryptic message like I need help cannot be an FIR. But information passed between officers can be an FIR. Note down that it is not necessary that the person giving the information should always disclose its name. What happens if the informant refuses to disclose his names? Then the officer who has received the information would state and say that I have received so and so information, and upon receipt of the information I am registering the crime by informing the same to my senior officers. Now that we have seen in detail what is an FIR, how FIR is given, what would amount to an FIR, and what happens after registration of FIR, that would be dealt in the next portion. Let us now see what is a criminal complaint and when does a criminal complaint come into picture. A criminal complaint is defined in section 2C of the Criminal Procedure Code. A criminal complaint is given to a magistrate either when the police officer refuses to register an FIR or the offence is non-cognizable in nature. Now let us see what is cognizable and non-cognizable offence. Cognizable offence is an offence in which a police officer without the permission of the court can investigate into the crime and arrest the accused without warrant. The list of cognizable offences is mentioned in first schedule of the Criminal Procedure Code. For example, offences like murder, dacoity, rape, cheating, some white collar crimes and some hard crimes. Now what are non-cognizable offences? Non-cognizable offences are those offences which cannot be investigated by the police until and unless there is an order from the court, and there cannot be an arrest without the court's directions. When does this come into picture? Now you have approached the police station under section 154(1), given down your complaint. The officer refuses to take down your complaint. Then it is mandatory under section 154(3) of the Criminal Procedure Code to approach the seniors. Now seniors as in whom? If it is a rural area, then the superintendent of police, and if it is the commissionerate, that is the city area, then a commissioner of police. It is mandatory that you give a written explanation or a written representation to the police officers, that is the seniors, and say that your crime has not been registered. As per the guidelines of State of UP versus Lalita Kumari, it is mandatory of the police officer upon receipt of an information of an cognizable offence to register an offence. After giving your written representation to the senior officials, please wait for 8 days. In 8 days, if your complaint is not registered, then you can approach the magistrate. Now magistrate, how would you approach? What would your complaint? Your complaint has to be a written representation which will have all the annexures along with the representations, the written complaints, the follow-up which you have done with the police stations, and whatever evidence you have. Along with all this, the most important thing which you have to annex with your complaint is an affidavit on solemn affirmation. An affidavit is an important because if a wrong information is given to the magistrate or police, then you are liable for prosecution under the Indian Penal Code. What happens when you give the complaint to the magistrate? The magistrate, upon hearing the complaint, if satisfied that a cognizable offence is made out, then will direct the police to investigate and register an FIR as per provisions of section 156(3) of the Criminal Procedure Code in a time-bound manner. Now, time-bound manner is, for example, the magistrate would say, peruse the complaint, heard the complainant, and seen the annexures, and I direct so and so police station to register the offence within 1 week, 2 weeks, 8 weeks, and report back to the magistrate. What happens if no offence is registered even after the magistrate's order? Even after the magistrate order, within stipulated time, if the offence is not registered, then the magistrate, upon an application for the from the complainant shall issue a letter to the concerned officer as to why contempt cannot be issued against him. Contempt will be issued to him if he gives an explanation to the magistrate that he registered the offence or he did not register the offence for the following reasons. The magistrate, after application of his mind judicially, can decide what will be done. Now what if the magistrate is not satisfied for registering an FIR under section 156(3)? If the magistrate is not satisfied under section 156(3) for registration of FIR, then the magistrate can call upon the statement of the complainant. This is commonly known as verification. Verification is a written statement, and after the written statement, the magistrate has a prerogative either to direct inquiry or to issue the process. The magistrate can postpone the issuance of process if he feels that some additional inquiry is done. Again, in the inquiry, the police officer is given certain time to report to the court. The police officer will report to the court, and upon hearing the police officer and perusing his report, the magistrate can proceed to issue summons to the accused, or it will be the magistrate's prerogative to either dismiss the complaint. What happens if the complaint is dismissed? If the complaint is dismissed, then the complainant has alternate remedies, that either filing revision or approaching higher courts. Now what happens when summons is issued? When summons is issued, it is the duty of the accused to appear before the court and give his say. When summons is issued, can the police arrest the accused? No, the police cannot arrest the accused when summons is issued. Also, when the court directs inquiry, then the police is not supposed to arrest the accused. Now what happens as per section 156(3) if the police register an FIR and does not investigate? The police, after registering an FIR, may at times feel that sufficient case is not made out. Then the police may not investigate the matter and inform the same to the complainant in writing. Thus, now we have seen what is an FIR and what is a criminal complaint. The basic thing is, generally an FIR is registered upon an information of an cognizable offence, and on refusal of the same, the complainant has a remedy to file private complaint before the court. In the detailed explanation needs to be seen in the sections of the Criminal Procedure Code. Views expressed in this video are as per my understanding and knowledge of the laws in India. If you like the video, please hit on the like button and comment and share the video. And if you have not yet subscribed to my channel, please subscribe to my channel. Till then, bye. Thank you.